In most Chapter 7 cases, the only time that you'll appear for anything with regard to the court is what's called the 341 meeting. That 341 is a designation in the bankruptcy code, and it's an opportunity for all of the creditors to meet, ask questions, and state their claims for the trustee. 9 times out of 10, if not even more often than that, nobody else appears on the call except for you, your attorney, and the trustee. I'd like to go over what to expect in that call because it is something that induces anxiety because people think, oh my goodness, people are going to be asking me about my debt, and maybe I'm not so sure I know the answers or know the best way to respond. Let me show you some questions that we can reasonably expect to be asked in the 341 meeting. I'll share my screen right now. Oh, here they are. Did you read and review your bankruptcy petition, including all of the schedules before signing it? So that's what I sent to you via email usually. And that was the reason I had to ask you to review everything, first of all, was to make sure it was accurate, but also because I knew that this question would pop up. So it's not enough to just say to your attorney, gee, I'd like for you to file my bankruptcy. I trust you, go for it. No, the bankruptcy court wants to make sure that you have read and reviewed your bankruptcy petition, including everything else before you signed it. Now, of course, we did the e-signing, but the idea is there that you had read it. Was the information correct when you signed it? Has anything changed since you signed your petition? Now, those two questions, in the very rare circumstance in which we had to change something, I've had situations where we had to change a social security number, an address, anything like that that might have changed since we actually filed the petition. Have you filed for bankruptcy before? When? Be prepared for this question. It will pop up. It was in the forms. It was something that I asked when I first spoke with you or when someone from my office spoke with you. But be prepared for that question and try to have, even if you can't remember the exact year, try to have a pretty good idea. Oh, it was 20 years ago. Oh, it was sometime in the 1990s, something like that. What the bankruptcy trustee is obligated to make sure of is that you didn't file a Chapter 7 within the last 8 years. Did you provide accurate copies of your tax returns? So when your attorney asked for the tax returns, it was because of this. We are obligated to supply them to the court. Do you owe spousal or child support? Did you list everything you own in the petition? Now, that's a really important question. Sometimes people say, oh, well, I want to leave this out of the bankruptcy, or I want to make sure that I keep my car, so I'm not going to list that in the petition. Remember that the exemptions are so generous that it's very unlikely that you would lose anything. So please, let's make sure we've included everything that you own in the petition. Do you own any interest? Do you own or have any interest in real estate? Now, what could constitute an interest in real estate? Perhaps you are a co-owner, or perhaps you are holding a deed, but somebody else is making the payments. The house is in your name, but you're making the payments. Or perhaps you are due to inherit a home and the process hasn't completed the probate process. Did you list all of your creditors, no matter who they are? Now, that's also a really important question. Again, some people think that they can hold one Visa card off to the side or one gas card off to the side. It's really hard to do in the era of automation. In other words, once you file bankruptcy, that number is transmitted even to entities that are not listed in the petition. A great example of this, the cell phone companies. Almost immediately, they get notice. And if you go to your cell phone account, you'll see bankruptcy pending or bankruptcy case, or this account is in bankruptcy, something like that, even though we never listed it. So please do not operate under the assumption that you can keep one card off to the side that was wholly in your name and that it will be safe from the bankruptcy simply because you did not list it. Now, it's different if you are an authorized signer on somebody else's account. That's a different situation altogether. But a card that has your social security number and your name cannot be held out of the bankruptcy simply because you have the intention of paying on that account. Have you transferred any property within the last 2 years? This is not really a deal breaker. If you were selling things in order to pay off some of your debt, that's still okay within certain guidelines. What we want to make sure is that you didn't do something wildly out of bounds, like sell a piece of real estate, net $1 million, and then try to file bankruptcy and get out of paying Visa their $3,000. Those are extreme examples. Examples of where it's okay to have sold property are situations in which maybe you turned in a car, or maybe you sold a car, paid off what was due on that note, kept an additional $500 or $600 just to pay the heating oil bill or the cell phone bill or what have you. If you've done that, please make sure that you mention that. Honesty is the best policy. Full disclosure is the best policy. What we don't want to have happen is that either after the call, maybe even during the call, somebody else would pipe up and say, oh, but wait, here's the record. This person sold a house, got $3,000 out of it, and they've not reported it at all. That $3,000 is probably protected, but you need to be able to speak up about it. Have you made any payments exceeding $600 in the past year? This happens a lot with family loans. So let's say my aunt lends me $1,000 and I know that I'm tight for cash, but I want to make sure that my aunt gets paid it back. Please be sure to mention that and explain the circumstances and explain the situation that your aunt is in. Maybe your aunt really truly needed that $1,000 as well. Are you involved in a lawsuit? Now, this is an important one. This isn't just the high dollar personal injury lawsuit, although they do want to know about that. This is also, did you have a creditor already sue you? We need to make sure that that is included in the bankruptcy. Hopefully, we've already talked about that before we get to the 341 meeting. Are you entitled to receive any inheritance or insurance proceeds? This is an important question. Some people laugh when they hear it because the trustee will kind of in a matter-of-fact way say, do you expect to inherit any money in the upcoming 6 months? Well, please don't laugh, but please do answer honestly. It's an important thing to know. By law, by the bankruptcy code, that is, you are expected to inform the court if you should come into some money after the case, after the 341, and even after the case is closed. Something that's not on here, do you expect to receive a tax refund? Now that is a tricky question, especially if you owe back tax. It's very unlikely that you will receive a tax refund because, of course, the IRS will take any refund from this year's return and apply it to back taxes that are owed. This year in particular, as we prepare taxes in 2020, it's very likely that people who were unemployed but did not have withholding will end up having to pay taxes. So for that reason, unless you are 100% sure that you will have a refund due to you, I suggest that you say, I don't believe that I will have a refund coming to me this year. Unless you really, really think you will, please answer it that way. Does anyone owe you any money for any reason? Now, this is another important question. It's not a joke. A lot of people want to say, yeah, well, if they owed me money, I sure would be tracking them down. But it's to find out, is there somebody out there who the day after your bankruptcy case is finalized could come up to you and send you $30,000? If so, you need to report that money and it will be redistributed amongst your creditors. Remember that the trustee's role is to sort of harness all of your assets into what we call a bankruptcy estate. And then it's up to the trustee to determine, well, of this bankruptcy estate, what is it that is exempt and can then be given back to the debtor? And what is it that can be simply liquidated? The debt that can simply be liquidated. So if you have more questions, please reach out. I look forward to hearing from you.